BRS MLAs disqualifications will be done due to change of party or not? What is the decision of Supreme Court?
My pleasant good morning to one and all. We are aware of the fact that the MLAs and MPs are changing the parties whenever after the election the party through which they are elected have not come into power. Sometimes due to political needs, sometimes due to personal needs, and also on some occasions by taking some consideration into their wisdom, they are changing the parties. We know in Telangana nearly about 10 MLAs changed the party, and one MLA by name Danam Nagender, he contested as an MP on behalf of the Congress party after electing through BRS party. What is happening? Whether such sort of activities are supported by Judiciary or condemned by Judiciary. For this we have to see, in a democracy, the rights of a party could not be permitted to be frustrated as per the observations of the Honorable Supreme Court on Monday while asking the reasonable time for Telangana Assembly Speaker to decide pleas for disqualification of BRS MLAs who decided and defected to the Congress. The Honorable Justice B.R. Gavai and K. Vinod Chandran, they were hearing two separate petitions. During the hearing, they asked an interesting questions, and when reasonable time within which the speaker is permitted to take decision, if not told by the speaker and submitted to the court may and will fix that time. In the hearing, the top court sought to know the reasonable time for the speaker to decide on the disqualification petition. The bench has asked the counsel appearing for the Legislative Assembly whether the reasonable time could also mean the end of the term of Assembly. Is it so? When the Assembly ends in 5 years, suppose in the first month itself the MLA changed the party, when will the speaker take decision? Can it be the last day of the 5 years? Then what is the use of doing it? The court asked, in your perception, what is the reasonable time? Reasonable has to be as per the discretionary meaning. The counsel appearing for the Assembly urged the court to keep the hearing after a week. Finally, the bench posted the matter on February 18. The court also observed, for any reason the speaker doesn't give the time within which speaker will take decision, the court may fix the time. Generally, in a 3-bench decision, as per the counsel for the petitioners, it is 3 months time. Reasonable time means, barring in exceptional circumstances. Whether this case comes in the exceptional circumstances or not, and whether the reasonable time means 3 months or not, and when will the court will fix the time, that is the Honorable Supreme Court will fix the time within which the speaker has to take decision, we have to wait and see. But for the present, what we understand is, the speaker who is elected by the members of Assembly generally represents and supports in the given circumstances as it appears only in favor of the ruling party. If that is so, if the speaker is given unregulated discretionary power to take up the issue on any date convenient to the speaker, he may not take the decision at all. So, what is reasonable time? means it is the time within which even a common man, when looks into, feels that it is correctly fixed and at the right time the decision is taken. Generally it is 1 or 2 months or at the most 3 months as fixed by the Honorable Supreme Court, but in exceptional circumstances it may be 1 more month or 2 more month extra time. But in the present case, even though lot of months are completed after filing the petition, nearly 10 months, no decision is taken by the speaker, and even the date on which the decision will be taken also is not informed by the speaker. In those facts and circumstances, we expect by 18th of this month, the counsel for the assembly on behalf of the speaker will definitely say the date and time when it may take decision. It is pertinent to note, even while and before taking decision, an opportunity has to be given to all the affected parties to submit their claims and contentions, and then only after following the principles of natural justice a decision has to be taken. But even for that, some day has to be fixed when they have to appear and give their answers, before which speaker can continue to have the further inquiry. But nothing is done till date. So unbridled power will always give a discretionary power which can be used as per the whims and fancies, which is not permissible under law, and in particular in a democratic country like us. So it is better in the interest of justice and to have the speedy justice and to check the parties and the MLAs and keep them as per the traditions or as per the democratic principles, to clearly envisage and keep or decide the time limit or upper limit of the entire process of conducting inquiry and the date by which a decision has to be taken by the speaker. Because after speaker taking decision also, legal avenues are there which can be completed only by taking long time by the courts. In those facts and circumstances, I humbly request all concerned, in particular, importantly, all persons who believe in the democracy, to see that have cooperation of all and take decision at the earliest and do justice and uphold democracy. Thank you very much.